We have an office of a data commissioner in this country, okay? And that one is about protection of data. All this information that you're giving to the government, that you're giving to everybody else, including your neighbors. Chairman nyumba kumi anataka kujua uko na sufuria ngapi kwa nyumba. That's data. What do they do with that data? It's important, and that's why we established Office of the Data Commissioner. That office is currently being occupied by Immaculate Kassait, who is our next guest. Madam Data Commissioner, good morning.
Good morning, Eric.
Welcome again to the hot seat of the Situation Room.
Thank you for the opportunity to be here once more.
All right. We're going to learn a lot more because this is something all new. And I know that your office has been doing quite a bit and facing hurdles here and seeing how to overcome those hurdles. You're here to tell us about that. CT will welcome you with the day's proverb. This week the proverbs are from
the Republic of Burundi. Yes. Don't tell fairy tales when the child has gone to sleep.
Don't tell fairy tales when the child has gone to sleep. Immaculate, what's your interpretation of this?
I think that's a good that's a good proverb to actually emulate emotional intelligence. Because if you take it literally, the child asleep, but if you want attention from somebody, then watch them. If they drift off, then you need to realize they're not listening to you at all.
Read the room.
Yes, yes, I'd say so.
Read the room. See, are they responding? How are they reacting? Sometimes if the child is dozing, maybe the story is too sweet, or maybe you're boring. Yeah?
You choose.
You choose. If a child is asleep, then now stop talking.
Have you considered the child may be pretending to be asleep?
Just so that you can...
They say you keep quiet.
Let me actually sleep.
Okay. See, you're telling me a story so that I sleep. Okay.
I'm asleep. So you ask the child, are you asleep? Yes.
Okay. That's a good interpretation. Now, recently we saw some communication that the Office of the Data Protection Commissioner has released new sector-specific guidance notes for the education sector, the communication sector, the digital credit providers, processing of health data. These guidance notes are designed to assist these industries in understanding and adhering to data protection laws, bringing the total number of published guidance notes to 8, in addition to the guidance notes on consent, data protection, impact assessment, registration of data controllers and data processors, guidance note on electoral purposes. What are all these things? Guidance notes.
Let me say thank you, Eric, for that question. The issue around data protection can be quite complex in terms of legal jargon. And being a new area, it can take people a difficult time to understand what it means. So what guidance note do is to unbundle some of the industries, and especially those where we have had either repeat complaints or lack of understanding. And that is why if you look at our guidance note, especially when we spoke about election, it came up when there were issues around election. Digital lenders, our complaints were leading in terms of digital lenders. Telecommunication, it's because they collect a lot of information. Health data, we share a lot of our information in health. And education cuts across, including children. So we targeted those industry to basically simplify what the law expects of them and what are the unique challenges within those sectors. That's why we came with a guidance note. It was not a work done with us alone. It was a multi-stakeholder based committee, which was appointed by our CS, Elio Dowalo. And then we came up with, we had representative from Attorney General, we had representative from Law Reform, we had representative from CAJ, Commission of, we had also representative from industry, we had representative from Communication Authority. So we had across, and also in addition to that, we had the Digital Financial Service Association, and also we had the Central Bank, we had the Private Sector Regulatory Authority and Kenya Private Sector Alliance. So basically we came up with a draft, we subjected them to conversations around what we are seeing, and then now we then published. Guidance note would say say it's below the regulations.
Okay.
So you have the constitution, you have the policy on data protection. Below the policy, you have the Data Protection Act. Below the Data Protection Act, you have the 4 sets of regulations we have. Below that, you now have the guidance note. There are easier way because it's easy to amend them. They do not have to go through a prolonged process. They are very specific to industry. If you look at all those sets of guidance note, because if you look at whether it is the telecommunication, we've given examples. What information is this that telecommunication industry or people in courier services collect? How do they store that information? What are the unique issues that come up in that state? And some of the unique issues, of course, is at times you can find them sharing information with third parties. And then at the end, we even guided them in terms of their checklist on what are the things they can ask as they continue to engage. When it comes to Ministry of Education, to education, the same. Private school, you remember one of the things we've had to deal with is concerns about a lot of information being collected on private schools and what are they doing with this information for their students. So it was also a journey to actually guide them in terms of what information they are collecting, how are they processing it, how are they storing it, how are they disposing it, how long should they keep them. So we guide them in terms of what are the bare minimums from the data protection, what are the international best practices. What kind of information are you collecting from the students? Can somebody object to that information? Can they, so we are basically bringing them to speed in terms of what are the best practices. So it helps them. It helps them because if you give somebody the Data Protection Act to then unbundle without examples, it becomes very complex.
It's jargon.
Yes, it can be legal jargon. For us lawyers, we are happy to have legal jargon after all.
For anybody who's in the space where there is an engagement with information that is public, that could or should be protected, that at some point should be private, do you think that there is enough in terms of awareness of what they can or cannot do? And I'm talking about anybody in the space as far as these areas that you've described, education, information, etc., etc. Anybody who operates in that space with this kind of sensitive information, do you think that prior to the act, while the act has been in place and established, and even today where it's practiced or being upheld, that they really are aware of what they can or cannot do, how they can or cannot store their information? Are we?
I would say we are not where we should be, but we are somehow made progress. If you compare to where we are, even when this office was established in 2020, and even when the act came into place, there was actually a research undertaken by Amnesty International. It was below 26%. We have seen that grow to almost 60%. We were funded to do a baseline by GIZ last year, the end of 2020 to 2021. But you could say it's also updated. You could see a growth to around 68%. We are still not. It would be good if every single person would then be so empowered that before they engage in sharing the information, they can actually ask relevant questions, because that is what the Data Protection Act does. It shifts the responsibility. It actually then shifts the responsibility to the data subject, where they are now empowered to ask questions, object to the information being used, to be informed what the information is going to be used for. So it would be good if everyone is asking those questions. In many instances, we still are not there. And that is why we have this kind of engagement we are saying. And also we have seen, including this year, we had awareness creation around 40 counties. We will be there when every single person can speak about data protection, but at least we have made progress. Yes. And it looks for it's an issue that would require continuous partnership. And in fact, my challenge many times to organizations that many times we have spoken about health education, health education as one of the issues. I challenge institutions to reinvent themselves and begin speaking about this of digital awareness, and especially digital safety, online safety, data protection, cyber security, as something we speak about every single day of our life.
Even after you've published these, guidance notes, right? So, of course, bill went to Parliament, it was passed. assented into by the president. It was gazetted as law. Okay, gazetted, that's enough. Regulations were drafted, even went to parliament. There was consent by parliament and consensus. Okay, gazetted as regulations. Now here you are, you have published these guidance notes. What are you doing to make sure that we get them? So, for example, those of us in the communication field, those who are in the health sector, those who are in the education sector, do you have a mandate to make sure that every school head knows these guidance notes on education?
It is part of our responsibility in terms of awareness creation. What we did at the point of preparing the guidance note is actually involve stakeholders. We had a round table with every single sector. The only one pending that is not concluded is one on security, because we still have to complete that. But the others, we actually met the key stakeholders on that. But beyond that, I like your challenge is to then embark on an awareness creation on this. Having done that, we have scheduled awareness creation with specific to those targeted institutions. Yes.
What are some of these unique guidance notes that go into sector-specific unique challenges or areas that they need to focus on? Let's say, for example, for the digital lenders, what is something that is specific to them that gets into the guidance notes?
One of the things that is unique to the digital lenders is them harvesting information. They were before the data protection, or when there was no regulatory framework to that. In that case, what used to happen is you get information and anything on you, your family,
all my contacts,
in your contacts, what you do, your spending preference habits, what your spouses are doing, how many times you're online, all this information.
They are mining all these data.
All that information, it was for use. But you see, now with the Data Protection Act, it puts a stop to that. Because now when it comes to, because you will find many times people who seek out to get loans on digital lenders, they are going away from mainstream loaners, because then they are more strict and they have structures. They want this which is easy for you to access information, to access a loan. Not much is, you don't need a credit history, or score. So you just come and say, I need this amount of money, you give me that amount of money. So, and then when they ask you terms and condition, you sign, you say, yes, can we access your contact list? Yes.
Can
we access? And then you find that they probably accessing more than you expect. They're accessing even your photographs, accessing your social media trends, accessing your contacts information, accessing, anything under the world.
You've allowed them?
Yes, you have. But you see, they also have a responsibility. Because the Data Protection Act calls them to order, because you're not allowed to collect all that information under the principles. There's a principle of data minimization. You only collect information that is relevant to me. So you don't need to know about my photos. Because, by the way, in some cases, there has been very serious situation of where people, then they're accessing your information and using that as a blackmail. And you don't need that. You just need my address. You need my name. You don't need to know my relatives. That is too much information. So the principle of data minimization calls you to order as a digital lender. The other principle that calls you to order is a right that I have, is a right to object. I can object to you processing my information. So that also brings you to order. Okay. The principle of accuracy. So the difference between you having access to my entire information and the difference of the Data Protection Act is telling you can only do so much.
Yeah.
And also the principle of limitation, purpose limitation. What that means, you can't ask Munga for my information and you're telling me it's for digital lending, and then the next thing you're sending me SMSs that you have a new product. We had this conversation, yes, for marketing, because we agreed that you're giving me this information for a specific purpose, but it's not for marketing. So you see, that is the difference. Those are the uniqueness that you're calling them not to access information that they don't need. And when eventually you pay your loan and you're no longer their customer, they need to delete that information. It's the right to be forgotten. If it doesn't happen, you have a channel for complaint. And the first channel for complaint is actually to write to them and tell them, please, and we have actually dealt with those cases. I was your customer, I completed paying your loan, please can you therefore delete my information from your database?
Right to be forgotten.
Yes, it's called the right to be forgotten. We often say it's not an absolute right, but you as a customer, because the reason you had a relationship with this digital lender was what we call contractual obligation.
Yeah.
You were paying a contract, you had a contract between them and you in terms of...
it was specific.
So, and it was specific.
Yeah.
So now you're spamming my email with a lot of information that I don't need. That is outside the scope of...
You haven't borrowed in a while.
Give us a ring.
Yes. So in that guidance notes, what we have done now is to actually give examples. And it's to guide the industry that this is what is allowable, this is what is not allowable. And so when we design your products, when you design your product as a digital lender, you install your apps in a way that you're not mining people's information. And you're also making sure you have put in place frameworks and governance structure that assure people of their privacy in as far as data protection is concerned. And this you've also seen when it comes to the digital lenders, the central bank regulations were amended to make sure that these are things they're taking into account. And I often say the issue around data protection goes beyond your daily ticking a box as a compliance issue. Many of those digital lenders would want to borrow loans from other countries where issues of data protection have taken very, very seriously. You do not want a reputation of being the violator of data protection, because then it affects your business reputation in the long run. Yes.
When we look at these guidance notes that have been sent to, that are then created for a particular sector, are they aware? Because we can consume them and we can look at them and say, okay, actually, this is interesting. An individual who has to engage or groups who have to engage with these entities, then one would assume that they then now are intimate with the information. But do the entities, are they aware that there's been an update in these guidance rules and these requirements so that they can also know how they can or cannot operate? I imagine a situation where somebody says, well, look, my friend, I have the right to be forgotten. And maybe some of these things have been updated in guidance notes that have come from the Data Commission. But they aren't aware. How do I put up a battle? Or rather, how do I put up a fight? Or are they the first port of call for such new information?
Let me say this. In a hierarchy, guidance notes are like at the fourth. So meaning, by now, if you're an entity in any of this sector, either you have interacted with us directly, or it has been a complaint. Because you remember I said one of the things that drove us to actually come with the guidance notes is complaints, the number of complaints. Or you have been fined, or there has been an enforcement notice. I often say it's interesting that at times the enforcement notice actually act like awareness. And also, like for instance, the issue around digital lenders, we went beyond duty call. We actually even went and did audits. Because I often say, for us as an office, it doesn't make sense for you to be carrying around a stick only. You also must go beyond carrying a stick to encourage people to comply. We did compliance audit for 40 digital lenders last year. I think last year, but one. Yes, so we did an audit where we tell you, when we look through your processes, we identify where the gaps are and tell you this is how you need to reform. In addition to that, what I had said earlier is we actually met them when we were developing the guidance note through their different stakeholders so that they are able to appreciate. Having said that, that's part of the reason I am here this morning, because we published this a month or so in January, December I think, is to actually then begin that journey of also awareness creation, to remind them there's a simplified version of your industry that you need to internalize to help you in terms of this compliance journey. So that, and then we also encourage them that it's important to have a data protection officer, even though not compulsory. It helps you in terms of your journey. we are encouraging institutions, including these ones we have identified guidance notes, to make sure that the issue around data protection finds its way in the agenda for the board and management, so that they set aside resources. They set aside, and when I say resources, it's both human capital and also financial resources. When we set aside that resource, it means you have a specific person given the task of data protection. So their work is to work with you, and we've seen improvement. There are days 2 years ago, when we started enforcement in 2022, we could see you'd write to people and they completely at times don't ignore it. So they are shocked when they get an enforcement notice. But now we are seeing, by the way, what people don't know, there's a growing industry of lawyers in data protection.
Right.
I think enforcement has shaken the industry so much that we now get very many letters from lawyers that we have received this query. And at times it's just a query. Please, can you explain what? Because it's part of fair hearing. We give you an opportunity to explain. So to your question, yes, we had roundtable. Yes, that's why we are here in terms of creating an awareness. Yes, every single industry which is on this guidance note has interacted with us, or there has been a complaint about that industry. Yes, so they have had an opportunity to interact with the office, and they also have very robust umbrella bodies like the digital lenders. They have a very robust umbrella body that is keen to clean up the space, because according to their statistics, people tend to borrow more from the informal than the formal.
Right.
Yes.
Data Protection Commissioner Immaculate Kassait, who is our guest this morning. The Office of the Data Protection Commissioner has recently published the guidance notes for various sectors, and you're still continuing to widen the sectors, I believe, Commissioner, right?
Yes, we are.
Okay. Now, the question has come in on information that then ends up in court. So you have been arrested by a police officer. They have taken all this data from you. They have taken your information, your ID, kitambulisho, wamayenu ni nani, all those. They pass it on to the Office of the Director of Public Prosecutions, who then goes to court. And the charge sheet has all this information. Number one, who's the custodian of all this data? And I mean, who's responsible for all this information? And at what point does it, disappear? Number two, when you're in court, what privacies do I have in court? In some jurisdictions, you're not allowed to actually have cameras in court. In Kenya, cameras are fair game in court. So what are the areas here that you need to focus on?
Well, let me say, when it comes to matters criminal and matters legal, there is what we call, there are almost 8 or 9 lawful bases for processing data. And one of the lawful bases, let me start with the easy one, which is contractual obligation, that I'm allowed to process your data because we have a contract, like the one I was giving for digital lenders. The other one is lawful purpose. And when it comes to, if we look through the Data Protection Act, some of those exemptions are actually around the judiciary. They're exempt when it comes to data protection. You cannot challenge the judiciary on the basis of data protection because they are doing a function which they are empowered to do under the law. So when it comes to lawful purpose, there is a government institution that is governed under the law to be able to do certain things. So they are working within the law, the regulatory framework. And to answer your question about the right to be forgotten, please remember, I did say the right to be forgotten is not absolute. If you have a criminal record, it doesn't mean that you are required after the crime, then your data is deleted. Some of that is guided by existing legal framework. It can live with you forever, including your civil registration information. It stays with you from birth to death.
Yeah.
So there is no right to be forgotten. So you're guided by the lawful purpose, majorly public interest. That is the other principle that would guide in terms of what the police are doing, the information they are collecting, how they pass it on to their next agent. Because when you look at the chain, the information has to move from one government agency to the next one for them to do what they are allowed to do under the law. Okay. So those are exemptions under the Data Protection Act. Of course, you might ask, Are there excesses? At times there are excesses, and those excesses are the ones we encourage. They should be brought to our attention as an Office of Data Protection if it falls outside that scope, if the information is being used outside what is provided for within the regulatory framework. The other one is about court. You see, it's a public interest. It's a public interest. But I think also our judiciary has made certain exemptions. You have seen they applied what I would say limitation when it comes to issues around children or sexual abuse cases. And even so they actually apply. You see, they will not give the full name of the person. They will actually then what we call anonymize. And those are some of the things that are encouraged in the data protection, anonymization, pseudonymization, so that you're also protecting the rights of a data subject. And we've seen that. In terms of the presence of cameras in court, that one I would say it's really up to the judiciary in terms of the framework they have provided for.
Every time one visits a building in this city, there's a book. When that book is produced, you also have to leave your ID. Then they write down all these details. That's data. Where does it go?
Yes, and I've said that one of the pending guidance notes is on that issue. We have developed a guidance note for security firms, private security firms, to guide them, because they are allowed for purposes of, and the truth of the matter is, we are all aware in terms of the uniqueness of our geographical location as a country and the threats we have in terms of terrorism. So there's a regulation that actually empowers them to collect information. The concern is what they do with that information, what they store it, how long they keep it. It's a concern we have observed as an office. We have developed a guidance note. It's one of the one that is pending for purposes of public participation, and then we publish it. Once that is finished, then there'll be clarity in terms of what they need to do, because there are limitations. You can't keep somebody's information forever, and they're supposed to just have for identification. So that is one of the areas and it is out of that concern that the public has raised. What is my information used for? How is it stored? For how long? And they're supposed to actually then also tell you that information in a privacy notice as you access any premises. This is your information, how long we'll keep it, what it is going to be used for, and what is the lawful basis.
So, Madam, it's therefore unlawful for the private security officer to, for example, look at their CCTV camera and the screen, and they notice two gentlemen entering a lift, and whatever those two gentlemen are doing, record it and share on social media.
Can you allow me to say? Let me say.
I'm giving a specific case that's been there on social media. I mean, you see all these cases. So someone notices something.
Let me say there's a gap. They
consider weird, awkward. But this is a private security officer. They have CCTV footage, cameras, right? It's written there. This building is under 24 hours of CCTV surveillance. Okay. But if you notice people misbehaving in one of those public areas, in a lift, and you're just a soldier manning the monitors, can you record on your phone and say, angalia, and share?
I think that's stretching it, because the purpose limitation actually guides you in terms of what you're collecting the information for. And if it's for security, it should be specifically for security or for purposes of the premises.
And if it's for security, it should be shared with security agencies, or can it be shared publicly?
You see, the unique thing about the security sector is without clarity in terms of what are the do's and what are they are not, then everybody tends to overstretch their mandate. Yeah. I would say this: the guidance note should be able to clear up some of those gray areas in terms of what is a do and what is not a do. Allow me, the next time I come here, we should have completed sharing the guidance note on private security and what is expected of them and what is not expected of them. Yeah.
Can you refuse to share your information banking on the guidance notes that the data protection gives to us? Can I say, actually, you know what? I don't know what you're going to do with this. Neither, and because I'm not protected, can I refuse? as people like CT often do.
In which case, because you see, then you'll be having a denial of service.
You're going to a
You
hotel.
see, when I say object to processing,
You're checking in at the hotel.
The concierge.
I said it's important to be clear about what it is. It's about identification. Oh, we are discussing still about around guidance not on security.
Yeah, because let me tell you
I
something.
see.
Because it's a big issue. Sorry,
That's
there are
not what's
lots of
happening here.
people.
I'm being picked on.
Well, that in
That's
addition
what's
to
happening here.
that, in addition to wanting to get
My
information.
security is being interfered with by these two individuals.
That in addition to wanting to get information, because folks are asking, what do I do in terms of reprieve? What do I do when, for example, the information that I gave, thinking that it was, an innocent piece of information, then is used in a way in which obviously is against my rights? Having been clearly cut out by yourselves as an office, how do I seek reprieve? How do I then make sure that I'm being protected really?
We are there to protect you. That one I can.
In that instance, do I pick up the phone and I call the office and I say, this and this is what is currently happening to me, and there's somebody who's going to attend to me at that moment, like 911?
I think that's making me a data police. Anyway, having said that,
but you get what I'm saying.
No, I get what you're saying.
So
there's a reprieve, and by the way, we have had compensation of people whose information right to data has been violated, and I want to encourage them to actually approach our office. And we are not just in Nairobi. And one of the things we embraced as an office is being online. And that way it's much easier for you to access. And even on online, you're able to file a complaint with our office. And we have a very limited time. Within 90 days, you'll know whether your matter is frivolous or your matter has merit. Because then we'll have asked for those questions. I would want to encourage the viewers or the listeners who have had those kind of challenging situations to actually complain to us. And we are also in Mombasa, we are in Kisumu, we are in Nakuru, we are in Nyeri, we are in Garissa, we are in Eldoret. In those three towns, we are in the Huduma centers. In these others, we actually have physical offices. I want to encourage them because we have actually rewritten history in terms of holding people accountable when it comes to abuse of personal data. If such an instance has happened, it's important it's brought to attention. And people are paying more attention now. Because like I said, it goes beyond just compensation of the data subject.
Yeah.
It also goes to the issue of your reputation as a company.
True.
Yes.
We have, from what one reads and what one observes, there are jurisdictions on this planet where if someone, say, is a known pedophile, and they are required by law, those laws, to identify themselves as such, so that people who live in that neighborhood know that we have welcomed a pedophile into our midst. That's data. That's information. When we talk about data protection, we're talking about information. Now, information usually resides in people. They even represent it. When we talk about data protection, I'm thinking of how this extends to the protection of human beings using data. Not just protecting their privacy, but protecting them. For instance, people think of murderers, people think of pedophiles, people think of people who've done things that we think are wrong societally. But when that information is made public and we read it in our papers every day, how can the commission that you head ensure that data such as this is actually made available? Not that this person is a thief, but that what you need to do in circumstances when you come across such a person. Now, I know I'm stretching this thing, but I'm stretching it for a reason. I'm stretching it because if I cannot relate data protection and what we've said to my everyday life, then that concept will not be very useful to me. I will pay lip service to it and I will acknowledge, but I will just go along my merry way and I will subvert whatever it is that I will just continue doing what I've been doing all along. As Eric would tell me now, City, ask the question.
I was about to land this plane, City.
The question is this. How do you ensure that the department you have that deals with communication packages information so that what you're actually saying is actually not just understood, but well received to the point where it can be actioned? That's really what I'm saying. That long journey was to get.
It's about actualizing the Data Protection Act so that it is a reality for the common one.
The people can relate to it.
They can relate. I think we have attempted that. And some of the very...
Tell me how you've attempted it.
Some of the very, very... What I can come to my mind is when we penalized a club in terms of
cultural
using
establishment,
using people's
photos for marketing.
That is so unique to anyone can relate to that.
Yeah.
Yes.
The other one which we have seen is actually on digital lenders. We've seen us taking punitive measures against some of these abuses. We've seen a reduction in terms of people. I'm not saying we're out of the woods yet, but we've seen a reduction. So those are things that that still do affect people psychologically, where personal information is accessed and you're harassed, and everybody, including your chama and your neighbors, because you're in contact and lipa hii deni ama.
Wow.
You see, that is some. You see that harassment was leading people to psychological. So that is something that relates, Kenyans relate to. The other one is a campaign we did last year where we are telling the youth, be careful in terms of the information. You don't say just yes, because this information is commercialized.
Don't just tick all the boxes.
Those are some of the attempts we have done. And like I said, we are not there yet. This is a journey. Part of the reason I'm here today is to create awareness. We continue to do this. We continue to challenge partners to take on this task of data protection, so that it's not just the Office of the Data Commission. It's something we are working with other partners, including the media. At every opportunity we have for professionals, for the public, we want to do that. Next year, next financial, we'll even go further by targeting public sector, with making sure we are working on people who are working in public sector and training them on basics on data protection, including seeing whether they collaborate with as low as the chief, because the chief is a very powerful person in terms of passing this kind of information and understanding. So that is what we are doing in terms of our social media pages, in terms of when there's Data Protection Privacy Day. We are not yet there, but we are getting
there. It's a journey. A debate ensued when you took action against that club that shared photos. And now the conversation was, okay, so to what extent are we supposed to comply, or do we comply? So we see very many of these establishments now have a sign that says photography and videography is likely to take place here. If you're uncomfortable, please do not enter. Is that sufficient? Number two, if you have all that, you as an establishment, you've taken all these measures, but then a reveler comes in called Eric, and he's taking videos and he shares from your club. Are you liable? No,
because that's a reveler. That is a reveler. It's not the club that is sharing that information. You see, they have to remember, the concern is for commercial
use.
And it must be a consent, informed consent, and somebody accepted to that.
Okay.
It's not enough to put a signpost that you're taking photos and you're going to video. You need to go an extra mile. A compliance journey includes beyond the registration. It includes doing your own audit process. How is this information collected? Are you getting consent from people? How will you use the information beyond? How long will you store it? It's a process. It's not just putting a sticker on there. That's not sufficient.
That's not enough.
No, that is not enough. It is not enough to just put
all this is new. Very new. Just when we're getting used to understanding what the internet is. Is the judiciary trained in these things that we're talking about? Because if it's new to me, it must be new to them as well.
We are in partnership. We actually sit on one of the technical committees in the judiciary. And we are in discussion with on how to make sure that everybody around the table is also trained on this issue. Yes, that is what I would say.
Police?
That too.
It's a journey.
Yes.
Okay, let's talk about health, because one of the guidance notes that you've released is on data, on health data. What are those unique areas that you found in the health sector?
In fact, if there is one very sensitive area, is actually health, and we are seeing it being an emerging issue. You'll be surprised how much of your information is collected in as far as health is concerned. It's very scary.
But information is collected every time you visit a health practitioner.
And a lot of it.
Yes.
And
sometimes very intrusive information.
Yes, that's true. When it comes to health, it can be very intrusive. And our concern is the health sector, and why we took up this beyond what we are seeing increasing. We could see one of the unique cases we saw was somebody sitting in a customer care desk, and somebody came, the information was collected, and then they were contacted 4 or 5 months later by the customer, by the person at the customer service desk. Something they were never supposed to do.
Yeah.
So you ask, how did that happen? So our biggest concern in terms of the health sector is the amount of data that is shared in that sector is enormous and very sensitive.
Is it legally shared?
And that's the question. That's why we are providing the guidance, so that we are saying the do's and the don'ts. When it comes to health data, what are the rights of the data subject? What are the rights? Can they object? And what are you collecting this information for? And how long are you keeping it? So we looked at it and said, when it comes to retention, disclosure, disposal, health institutions have to apply a higher principle, because that information can be misused. Imagine your information of your health and your health status is shared with, I like to say, insurance company. They can then decide what your premium you're going to pay.
But that's not usually the case, because when you go for certain policies, they actually want you to go for a health check, and that information is not given to you. It is sent.
But that one, you remember there's a contract between you and the insurance company.
Yes.
But there could be situations where this information could be processed in the back end without you see.
Yep.
And then they are able to tell you what high risk you are or not. Or it's able to be used for other reasons which you did not agree to.
And you're saying that should not be done?
No, you shouldn't process my information unless it is for research, and then in the health facility research, it's supposed to be pseudonymized or anonymized. It's not supposed to identify me as a person. So, but can you imagine if that information ended in the wrong hands? So that is why for us, health became a critical aspect of trying to actually then give them a guidance on the do's. And please remember, apart from school, it's the one thing we relate to so much.
Yep.
Every single, there's a health facility in the smallest of unit, a small clinic somewhere, that in every single village, even if we were to take county wards as the smallest unit, 1450. Yes.
They're collecting data.
Yeah.
Thank you very much for joining us today. Immaculate Kassait, the Data Protection Commissioner, has been our guests, informing us of the work that they've been doing at the Data Protection Commissioner's office, and also what we need to know about our data and how to protect our own data.
This is the Situation Room, the only way to start your day.